My name is Jason Deloach, and I am handling the estate planning portion of the presentation this morning. I'm with the law firm of Alexander and Cleaver. And again, congratulations on your pending retirement. And we have a lot to get through today, so let's get started. Okay, first foremost is a disclaimer. This presentation is for general information only and is not intended to be legal advice. There is no attorney-client relationship between the two of us or all of us, so it's just being given for general purposes only. You need to consult a competent legal advisor for guidance concerning your situation. Okay, this is an outline of where we're going this morning. We're going to talk about wills and estate planning, financial powers of attorney, and planning for disability. Okay, so the first portion is wills and estate planning. When people die, they have property that can fall into two categories: probate and non-probate assets. First, talk about probate assets. Wills dispose of assets subject to probate. And that means that these are assets that you own individually or as tenants in common, which is the second bullet point under wills. I think it's pretty self-explanatory about property that you own individually. That would be like a car or a house where your name is the only one on the title. Tenants in common is where two people own property. Let's say use a house, for example. You own a house tenants in common with a friend of yours. That means each one of you owns a 50% share in that property, that when you die, the first of you that dies, that 50% will be yours to fall through your estate. And the surviving tenant would keep his or her 50%. And the second bullet point, assets where beneficiary is not named. So the most common example there is for life insurance. If you have a life insurance policy that does not have a beneficiary named, then that money will then go into your estate and be subject either to your will or to the estate administration process. Now going there to the next dash is assets naming a beneficiary pass outside of probate. So this is an example of a non-probate asset. So let's talk about the life insurance policy. Most life insurance policies have a beneficiary on them. Maybe you've named your spouse or significant other or your children. Once you die, that money will be payable directly to them. It would not have to go through the probate or court process in order to obtain that money. The same thing with your individual retirement accounts. If you have a beneficiary on there, they won't have to go through the probate process in order to get their money. And in the other remaining bullet points, the same as for trusts. We'll talk about that a little bit later on. But you set up a trust and you name beneficiaries under that trust. It will not go through probate and will be a non-probate asset. The fourth bullet point, TOD stands for transfer on death, and POD stands for payable on death. These are for investment accounts and bank accounts. If you have a bank account with Bank of America right now, you can name a payable on death beneficiary. And that means upon the production of a death certificate, the bank will then turn the funds over to your designated beneficiary, and that will not have to go through the probate process. And when I say probate process, what I'm meaning is that court proceeding that's required when you die with property in your name only. So that's what I mean by probate, the probate process. And the last bullet point is joint tenants with right of survivorship. This is the exact opposite of the tenants in common that we talked about in the bullet point above. If you die as joint tenants with right of survivorship on a piece of real estate, then the first of you that passes away will no longer have any interest in that property. It will not fall into his or her estate. The entire asset now belongs to the surviving joint tenant. So that's a big difference between that and the tenants in common. Okay, so we talked about a little bit what happens with a will. Here's the reasons to have a will. And basically, I want to just very briefly touch on what a will is. And many of you probably know what a will is, but it's a written document that outlines how your property is going to be distributed upon your death. It needs to be witnessed by two witnesses and has to have certain formalities to it. But the basic premise of a document, the basic thing you want to get done with your will is for the orderly distribution of your property upon your death. Now, why do we want to have a will? we have bullet points to say why you should have a will. It's essential if you want assets to go to individuals of your choice in portions different than provided under Maryland law, or to place assets in trust. Now, that part that I'm talking about in portions different than what's provided under Maryland law, we're going to get into that a little bit later. But if you die without a will and you have property in your name, then the law has written a will for you, basically, and says who needs to get what, and it's very rigid. You can't deviate from it. So we'll get into that a little bit later on. That's called an intestate succession, but the will allows you to make the determination on what happens with your property. And the will gives you the option of placing property in trust for children until they reach a certain age, or disabled adults or disabled child. The second bullet point, you have control over how the property you worked hard for to get over your lifetime, you determine how it's distributed. You made $1,000 or $100,000 that you left for your family. You get to decide how that's distributed. Very important. The third bullet point, the will also permits you to designate a personal representative. Now, and not a court. Now, the personal representative, and you may have heard the term executive before, this is the person that's going to be in charge of the estate administration process. They're going to make sure that your will is complied with, and they're going to make sure that the law is followed during the probate process. A lot of times, it's not the smartest person in your family that can do this. You decide who is going to be able to do it, number one, who has the competence level to do it, but also to have the sort of compassion that's needed to be a personal representative, and sometimes to not manipulate, that's the wrong word, but to definitely cater to people who are mourning your death. And sometimes when people don't get, they don't get along, the personal representative needs to manage that. So you're best positioned to figure out who that person is and to name that person in your will. If you don't have a will, then the court is going to make that determination. And a lot of times they don't make the right determination because they just don't know family history. And the last bullet point, the will eases distributions to minors. It allows you to set up trusts in your will for minors. Minors are not deemed to be competent enough to handle their own financial affairs and their property. So the trust allows you to designate someone to handle their money until they reach an age that you deem appropriate. Okay, I talked about this a little earlier. What happens when you die without a will in Maryland? Okay, now, if you die without a will in Maryland, the legislature has written one for you. You are deemed to have died intestate, and your property will be distributed as follows. Each one of these bullet points takes into account the people that survive you when you die and you have died without a will. So the first bullet point, say you die and you leave a spouse and minor children. The spouse will receive half of your estate, and the remaining your children will split the remaining half. So if you died with $100,000 estate, your wife would get $50,000 and your children would split the remaining $50,000. Now, I don't think that on the surface, many people would do this. If somebody sat down and did a will with their husband or their wife, in most instances, you would leave all of your property to your spouse first. And then if your spouse died before you, then you would leave it to your children. This does not allow you to do that. This would $50,000 would have to go to your children, and your wife or your husband would then have to try to manage, without you on that $50,000 that this law limits them to. I think in a broad amount of cases, that is not what somebody would want. The second bullet point, if you die, you're survived by a spouse and adult children, then it's a little bit more favorable to the spouse. He or she would receive the first $40,000. So in our $100,000 example, he or she would get $40,000 plus one half of the remaining estate. So after you give the spouse $40,000, that means there's $60,000 remaining. The spouse would get half of that, which would total $70,000, and the remaining $30,000 would be split amongst the surviving children. So that's a little bit more favorable to the spouse. But in most instances, if you have adult children, we hope that they are self-sufficient and do not need any portion of your estate that's taken away from your life partner. someone who helped you accumulate that wealth for you. Uh, the best, in most cases, in most instances, especially with adult children, when people sit down to do a will, they leave everything to their spouse first, and then to their children should their spouse die before them. And the third bullet point, if you were survived only by your children, then your children receive everything equally. I think most people would agree with that. But again, there are examples, plenty of examples over the course of my career where my clients did not want to do that because they have maybe put a down payment on a house for one child and wasn't able to do it for others. So they account for that in the will by leaving a little less to the child that they've already helped out financially. If you're survived by a spouse and your parents, but no children, then if you have been married for more than 5 years, then your spouse will get the entire estate. But if you've been married for less than 5 years, then we go back to that calculation for the adult children. The spouse gets the first 40,000 plus 1/2 of the remaining estate. So in our $100,000 example, your spouse would get 70,000 and your parents would get 30,000. And if there's no survivors other than your spouse in the next bullet point, then your spouse will receive the entire estate. And the law goes on to get to more distant relatives as you move forward. So that's how it is. I think what you can get out of this is that it's good to have a will, because a lot of these scenarios, most people wouldn't draft their will like this if they had a surviving spouse. Okay. And I would say in 95% of my cases, spouses come in together to do their will and they leave everything to each other first, so that because they've accumulated all of this wealth together. Now, the one caveat to this is if you have a blended family, this is your second or third marriage and you have children, each side has children, then things can change there. But for the most part, spouses leave everything to each other first and then to their children. Okay, so we talked a little bit about a trust. Okay, a trust is, in a lot of senses, it could be a will substitute, or it can be part of your will, as we discussed earlier. Some of the examples and some of the characteristics of a trust. The first bullet point: the trustor or grantor creates a trust. This can be a self-sustaining document. It can be a separate document, or it can be a trust in your will. Second bullet point: you designate a trustee that administers the trust. Now, in a lot of cases, you can appoint yourself as trustee, and we'll talk about this a little bit later on. And then you can manage the trust assets as you deem necessary. But in most instances, you have to designate a trustee, and that person obviously must be trustworthy. They must be able to be relied upon to carry out your wishes without any hesitation. And the third bullet point is a beneficiary. The beneficiary benefits from the trust. They receive income or principal from the trust. So what types of trusts are out there? The first bullet point talks about a revocable trust. And the grantor can change terms or remove assets, hence revocable trust. That means it could be revoked, it could be terminated at any time, and he or she can change the terms of the trust. It's established during the lifetime. Now, what I didn't tell you about the will before, the will is a document that becomes effective at your death. So the day you sign it, it's not an effective document. Okay, it can be revoked, it can be torn up, it can be, it can be changed. It doesn't become effective until you die. These trusts that we're talking about are different. This is established during your lifetime, and it becomes effective upon execution. The third line there says requiring retitling of assets. The reason why the trust works for people is that it avoids probate. And the way it avoids probate is, if you do it correctly, you retitle all of the assets that you own individually into the name of the trust. So using me as an example, the Deloach Family Trust. If I put all of my assets, my house, my cars, my everything into the name of this trust, then I won't have to go into probate. My estate I won't have an estate to go into probate because I don't have anything in my name individual. So it requires the retitling of the assets in order to make sure that this trust works for you. So, example, if you own a house, you got to get a new deed done. Take my name off of it, Jason DeLoach, individually, and put it into the name of the DeLoach Trust. That means I don't own it when I die. And I technically don't own it while I'm alive. My trust does. So you have, and same with your cars and your bank accounts. You got to retitle those assets. Now, the fourth line there says more expensive to prepare. It is much more expensive to prepare a trust. Okay, it could be, upwards of 5 scene trusts that cost $7,500. Okay, as opposed to a will that can run you less than $1,000. But the reason why it costs a little bit more, a lot more, is because there are much more involved documents. But also there are other costs that are associated with it. In order for you to change the title to your deed on your property, that's going to require the use of an attorney to prepare that deed and to file that deed. So these trusts are much more expensive to do than wills. The next bullet point is an irrevocable trust, and in this trust, the grantor cannot change the terms. That's why it's called an irrevocable trust. So once you sign this trust, you can't change it. Okay, it's rigid. All right, and again, it's established during the lifetime. So once you sign it, it's effective right then and there, and it's mostly established through a will. So it'll be contained in a will. And again, it requires retitling of assets, just like the revocable trust. And again, it's more expensive to prepare. Now, these trusts are used to try to neutralize estate taxes and some other benefits that and really it doesn't do that anymore. But it does give some sort of tax planning, and people with substantial assets typically use these trusts. But the other thing that it does is it gives some privacy to your death. All probate proceedings are public record. So when you die with a will and you have to go through probate, if people want to know what's going on in your estate, they can go to the courthouse and figure those things out. They can get those documents. With these trusts, they are not filed with the court, and it remains private. So here are some of the uses of the trust. Probate avoidance. We just talked about that a little bit. If it's set up properly, then you should not have any assets in your name at the time of your death, and then you won't have to go through probate. Second bullet point, control wealth from the grave. You can do that. You put in a trust, you set up a trust, and then you can determine when your beneficiaries get money throughout the process. So you control wealth from the grave, so to speak. You can give principal to one person and income to another. Trusts are very, very flexible. One of the benefits is you can ensure children of the first spouse to die receive inheritance while letting spouse have access to income. So it's a very flexible tool. The fourth bullet point, protect funds for a spendthrift or for a minor or for a disabled or incapacitated adult. So a spendthrift is somebody who you give $100 to at 12 o'clock in the afternoon, and then by 12:30, the money is gone. Okay. I know a lot of spendthrifts. So the trust allows you to set up a structure on how that individual would get money, how much, and then when they would get it. So it's very useful there. And it has all of the same benefits that we talked about earlier about trust for minors and another benefit for disabled or incapacitated adults. But the one thing you do need to be careful of in using this, if you're trying to use this tool for a person who has a disability, they may lose their public benefits if they are if they're deemed to have too much wealth. You have to qualify for public benefits that we'll talk about a little bit later on. But you got to make sure that you're not complicating their ability to get government benefits if you make them a beneficiary under your trust. And there's, as I stated a little earlier, the last bullet point, there are some estate tax planning benefits to using trusts if you're at a certain income level. Okay, we're now to federal taxes, federal death taxes. And this is a portion of the seminar where I usually see people glaze over. Okay, taxes are very complicated and seminars are given solely on taxes. So we're going to jump through this and try to give you some basics of it. But again, death taxes can be a seminar of its own. So the first bullet point, probate and non-probate assets are taxed. So if any of your, your life insurance, anything that has value at the time of your death are going to be subject to the federal death taxes. And we call them federal death taxes. I put death in there because these are the taxes that are generated once you pass away. Okay. The second bullet point, in general, assets passing to U.S. citizen spouse, not taxed. So this is called the marital deduction. It's a somewhat complicated process, but as long as you have a U.S. citizen spouse, there's not going to be any taxes to your spouse. It's deferred to when the second spouse dies. So that is called the marital deduction. And so when your first spouse dies, there's no taxes, but the second spouse to die, then that's the point where the death tax will kick in. Now, at this point, with the third bullet point, the federal estate tax, right now, the federal estate tax limit is $11.7 million for individuals and $23.4 million for couples. So what that means is if you're not worth $11.7 million as an individual, then there will be no estate tax associated with your death. If you're worth $11.8 million, then there's going to be an estate tax. And as you see at the bottom of that page, the minimum rate is 40%. So whatever there is over that 11.7 million, that number is going to be taxed at 40%. Okay. And for couples, it's $23.4 million. And if anyone in the audience is subject to this tax, congratulations. Okay. But these tax limits were raised significantly by the Trump administration. During the Trump administration, they bumped it up significantly to try to lessen the tax burden for Americans. And you'll see there it says portability. What that means is portability means that the surviving spouse can use any available estate tax, the marital deduction that was not used prior to the surviving the death of their spouse. So if there's 20 million left, they can use that at the time of their death to neutralize the estate tax. Okay, it gets a little complicated, but again, that's something that we can have a seminar on its own for. And again, there's an annual inflation adjustment, and the minimum rate again is a substantial 40%. There are also state death taxes in Maryland and DC. I don't know if we have any DC residents, but in Maryland, again, they allow that portability we just discussed. And in 2021, there's a $5 million threshold. So that's much less than the federal estate tax. So if you die in Maryland, $5.1 million, then you're going to have to pay the 16% on that $100,000 that's over the $5 million. Okay. And in DC, there's a $4 million threshold in 2021 with no portability, and the maximum rate is 16%. Virginia, there is no Virginia estate tax. So if anybody's living in Virginia, congratulations to that. Now, I note there that legislatures can change policies. That is something that you have to keep an eye on because taxes and death taxes are always front and center at every legislative session. So you must keep an eye on that. Now, Maryland also has what is called an inheritance tax, and it's a 10% tax if a bequest to beneficiaries other than direct descendants and in-laws, spouses or siblings or charities. So what that means is anybody that you leave property to that is close to you in relationship and blood, meaning your spouse or your children or your siblings, they won't have to pay the 10% inheritance tax. Okay, they won't have to do it. But if you leave property to a friend or an uncle or a cousin, the 10% may apply. Okay, so keep that in mind when you're doing your estate planning. And in our wills, we usually say that any inheritance tax will be paid by the estate. Okay, but if the will does not say that, then that 10% needs to come directly from the beneficiary. And the second the second line there says the tax can go up to 11.111%. That applies if the estate pays. So if the estate is going to pay the inheritance tax, it's a little bit more expensive to do that. And the next line, all assets are taxed. There's no minimum. So life insurance and small probate estates are not subject to the inheritance tax. Okay, so if you're worried about life insurance, there is no inheritance tax for that. And there's the second line, the next line says a clawback if substantial gift within 2 years of death. What that means is if you give a $50,000 gift to your cousin, okay, in 2021, and you die in 2022, what that means is the law says that can be brought back, okay, and we can tax that at 10% because you died within 2 years of giving a substantial gift. All right. So that's a pretty onerous provision, but it's beneficial to the state. So that's what that means. If it goes beyond 2 years, if you give it you give that $50,000 gift in 2021 and you die in 2024, then there's no inheritance tax. And the next line, inheritance tax, is a dollar for dollar credit on the Maryland estate tax. That's getting a little bit complicated, but it's a way to neutralize the tax, the Maryland estate tax. Gift taxes. There's a federal gift tax. There is no gift tax at the state level. There's a unified federal estate and gift tax. That's a somewhat complicated process, but it's very beneficial to people who are giving large gifts during their lifetime. A lot of rich people who have substantial means, it's a way for them to give gifts during their lifetime and be a neutralizing factor on their federal estate tax return when they pass away. Lifetime gifts added to estate at death to calculate the tax. So that's where that unified federal estate and gift tax comes into play. And for a year, you have a $15,000 per person per year exclusion of the gift tax. So you have to be careful with this. I mean, if you give $30,000 to your grandkid for Christmas, then you're going to have to file a gift tax return. Okay. If you're going to give anything over or close to $15,000 as a gift during the year, you should consult with your tax professional. All right. And you have to keep track of the money that you give in installments during the year, because that can easily exceed $15,000. And if it does, you're going to have to pay. You have to file a gift tax return. Okay. So we're pivoting now from what happens when you die to what happens while you're alive, and you may need some assistance. So we're going to be managing our financial decisions. Many of you may have heard of a financial power of attorney. Documents that many people have, very common, but very powerful. You will never sign a document that's more powerful than a power of attorney. Okay, because essentially you're giving someone the authority to handle and manage your financial affairs. So we have a scenario here. Problem: a spouse, relative, or friend does not have legal authority to manage your affairs if you are unable to do so yourself. So many people are of belief that, hey, my spouse can just walk into a bank and handle my affairs for me. That's not true. Okay, just because you're married, it doesn't give your spouse the right to handle your bank accounts if your name is the only one on it, and to sell property on your behalf if your name is the only one on that property. Okay, so you'll be in and the problem is if your spouse is then falls into a lapse of incompetence or mental incapacitation, then you don't have the legal right to do anything. Okay, just because you're the spouse or you're their best friend or you're their significant other. It doesn't matter. The law doesn't care. So the preferred solution is a financial power of attorney. Now, under a financial power of attorney, the principal, which would be you, appoints an agent to have authority to make financial decisions for the principal. Now, as long as you are competent, you do not relinquish authority, right off the bat. I mean, it can be effective immediately, but it usually people don't do that. It's effective only upon their incapacitation. But as long as you have your full competence, then your agent won't be able to do anything on your behalf or do anything counter to what you want to be done. A financial power of attorney can be broad or narrow. It could be, hey, I want you to handle this this real estate transaction. Okay. Or I want you to have authority over my investment account. But mostly, in order to make it really effective, it should be broad, because you don't want to have, you lapse into a state of incapacitation and your agent to be limited in any fashion to handle your affairs. The goal here is to make sure that you have some security that if you get sick and you can't manage your own affairs from a mental standpoint, then somebody that you believe in and that will do it properly can step in. Which leads me to the next line, which says your agent must be trustworthy. Okay, your agent is going to have full access to all of your assets, and you got to make sure they're not going to convert those assets to their own use. So they have to be trustworthy. And the other thing is they have to be competent. Okay, it's not enough to, hey, my best friend is the person I trust the most, but if their own financial house is in disarray and they can't manage their own financial affairs, they're not going to all of a sudden become excellent at doing it for you. Okay, so you have to take that into account. And you can have more than one agent concurrently or consecutively. So what that means is you can name co-agents. You can name your brother and sister as your co-agents, which means they both would have the authority to work for you, either acting jointly or what we say acting severally. Either they have to act together on everything, or one can act without the other. And what consecutively means is that you can name your primary agent and then name an alternate. If the primary agent can't do it or they predecease you, then you already have an alternate in place in the document. Now, some of the other requirements for a financial power of attorney: the principal must have legal capacity to sign the document. I got into this a little bit. Once someone reaches the stage where they don't understand what they're signing, or they've had a diagnosis of dementia or something of that nature, then they don't have the legal capacity to sign the document. Okay, and I've had cases where people have had an initial diagnosis of dementia. Depending on where they are right then and there, they still may be able to do it, but I require a doctor's note suggesting that they have the capacity at that time to sign the document. But there's going to reach a point where they just don't have the capacity to do it. If they haven't signed one at that point, then they are legally they can't sign one. The document must be specific enough to allow third parties to accept the document. Most attorneys have power of attorneys that are very specific. So the problem where this comes into a problem is when people try to draft them on their own. And there may be ways to interpret the language that's not favorable to that person being able to do what they want. So the document must be specific enough. And if you're going to do a power of attorney, I strongly suggest, with all of these documents, I suggest that you get an attorney involved. The document can go into effect immediately or spring into effect at a later time. So what this means is that if you can sign a power of attorney on Monday and make it effective immediately, meaning that person that you designate as an agent will be able to handle your affairs for you as long as they have the document in their hand. Okay. Now, that doesn't mean that they can make decisions that are counter to what you want. All right. You're still in charge, but they will have the authority to act on your behalf immediately. And that gives some people flexibility that if they don't want to go and deposit something in a bank account, or better example, if they want to withdraw money out of a bank account, they can just send their agent to do it if they don't want to do it themselves. That's sort of the flexibility, but it can be very dangerous to make it effective immediately. Or it can spring into effect at a later time. What that means is it can become effective only upon your incapacitation. So once 2 doctors declare you to be mentally incapacitated, then it comes into effect then and only then. And the power of attorney terminates when the principal dies. So if you signed a power of attorney in 2020 and you die in 2021, that power of attorney dies with you. That means the person that you appointed as your agent under the power of attorney has no more power to do anything with your assets. Okay. And the last line there is the Maryland Power of Attorney law. There is a law that came into effect around 2010 that basically said if a power of attorney is drafted a certain way, meaning in accordance with the new law, then banks have to honor it. There was a time when banks, before this law, there was always the risk that a bank would not accept a power of attorney because they wanted the person to sign their own forms to create a power of attorney. Well, that put people in a bind if their loved one had already reached the stage of dementia where they couldn't legally sign a power of attorney, then they were stuck. The bank is not going to accept the one they signed with an attorney. They only want their own form signed. So unfortunately, that left the family in a position of having to go to court to get a guardianship just to get access to the person's bank account. And that was not a good thing. So they put this law into effect that should eliminate that problem. So what are alternatives to a power of attorney? Again, the trust. Under the trust, you appoint a trustee to manage the assets. You can do that in a trust. You can also have the assets must be titled in the name of the trust. Okay, so again, that's what we talked about. You have a bank account, you have a house, you want that bank account and that house to be titled into the name of the trust. Again, the trustee must be trustworthy. We talked about that. And the trust may survive the death of the grantor, which is different than the power of attorney, because again, the power of attorney dies with you, a trust survives you. Joint ownership. If you want somebody to have access to your bank account, you can give them joint ownership. That's one way to do it. Gifting. Listen, if there are assets that you want the person to have, just give it to them. Okay, again, keeping that gift tax in mind, but gifting is a way to give that person ownership of the asset so they can do what they want with it. And guardian of the property, you can appoint someone to be guardian of property in your documents, and that would alleviate the need for a power of attorney. A lot of times the court has to appoint a guardian of the property, but you can also do it in various documents. Okay, so that ends the presentation on managing the power of attorney for financial. Now, I understand that there are going to be others that cover managing healthcare decisions, so I'm not going to spend too much time on this, but there is something called a Healthcare Advance Directive that's broken down into Part A and Part B. Part A allows you to appoint a healthcare power of attorney, okay, a power of attorney for healthcare. They would do the same thing that the financial person does, but this would be strictly for medical. So anything you could do from a medical standpoint, they would be able to do from a medical standpoint. So that's Part A. And Part B of the Advance Directive is what we call a living will, and that is simply you making decisions on whether or not you want life support. And if you fill out Part B saying you want life support or you don't want life support, there is nobody that can come back behind you and say, no, I want to do the alternate. I want them to have life support, or I don't want them to have life support, even in the person that you appointed in Part A. Whatever you put in Part B is what the doctors and hospitals have to follow. So that's all I'll say about that. And I think the majority of this is going to be covered in another part of the presentation. So I'm going to now scroll through several pages to get to the next topic. Okay, planning for disability. Planning for disability is for, disabled families are dealing with disabilities at a higher rate. I just read something the other day. For some reason, I think it's with people being evaluated more. There are more Americans are living with mental disability. So there's several ways to deal with that. The first one is called a special needs trust. And these trusts help ensure and preserve the financial security and lifestyle of a disabled person who qualifies or expected to receive public benefits. They allow the disabled person to receive supplemental assets in the trust while still qualifying for public benefits like Medicaid and supplemental security income. Funds can be used for education, hobbies, or vacation, but not for food or housing, which are covered by SSI. The use of funds is tricky with several exceptions. You must be careful. And if you're thinking about doing one of these trusts, you absolutely have to consult a competent legal attorney. So there are three types of these special needs trusts. There's what is called a first party trust. And these trusts are used when the beneficiary has her own assets or expects to receive assets that will make her ineligible to receive public benefits. this trust must be irrevocable. So if it's established, it can't be revoked. They're typically used when the beneficiary receives an inheritance or proceeds from a lawsuit. The beneficiary must be under the age of 65 at the time the trust is established. The government has a claim against the remaining trust assets, if any, for reimbursement of any Medicaid benefits received by the beneficiary during their lifetime when the beneficiary dies. So the government has a right to get reimbursement. The second type of trust is a third-party trust. It's used by a family member or another third party, often established in the will or living trust of the donor for the benefit of the disabled person. This trust can be revocable, and the reason why it can be revocable is because it's the assets of someone else that are being used, so it can be revocable. The main difference between a first-party trust and this third-party trust is that the government has no claim for reimbursement for the beneficiary's receipt of benefits. Okay, so that's a big difference. And the last trust is a pooled trust, which is established by a nonprofit organization with several accounts for individual beneficiaries within a master trust for purposes of investing the assets. It accepts contributions from many beneficiaries. Each beneficiary still owns his or her own account within the trust. So there are organizations who specialize in handling these pooled trusts. So if you're thinking about if you have a disabled family member and you think one of these could work, definitely contact an attorney. These are very specialized trusts, and there are only a handful of attorneys that do that. So definitely look for those. And my office does not handle these. So I only know 3 attorneys really that handle them. I'm sure there are more of them out there, but these are very specialized trusts. Okay. Another tool is what is called the ABLE account. And this is a fairly new tool for families. It allows you to set aside up to $15,000 a year, $500,000 per life of the account for a person who was disabled prior to age 26 for qualified disability expenses. Growth is tax-free, and qualified expenses include education, housing, transportation, legal fees, healthcare, etc. Eligibility for public benefits are not impacted by these accounts. Like the special needs trust we discussed above, you can save up to $100,000 without it counting towards the $2,000 SSI asset limit. That's significant, okay? And government is not required to be reimbursed. So these accounts are available in Maryland, DC, and Virginia. So that ends my presentation. I hope that it was helpful to you. And I hope that all of you have learned a lot and you're working towards a successful retirement. Thank you very much.